Welcome. My name's Helena Kennedy. I'm the principal here at Mansfield College, and it's my great pleasure to welcome you tonight to the last in the Mansfield series. And not only is it the last in the Mansfield series, it's the last in my Mansfield series, because I'm heading off. I'm heading off now. I'm stepping down as principal of Mansfield, and I've had a wonderful, wonderful time. And I particularly have enjoyed establishing the Mansfield series, which will continue, I promise you, into the future. But it's been a real joy for me, and it's been great getting to know so many of you. But tonight is special, because as I finished up, who better for me to invite and persuade to come than the head of my own chambers? And he's the boss, basically. And so I managed to persuade Geoff to come back to Oxford, because he is in fact an Oxford man. Geoffrey Robertson, QC, is one of, I think, the greatest lawyers extant, still operating in the universe. Anyway, he, as I've said, is the head of my chambers. Geoff is an Australian. He was born and brought up in Australia. He went to Sydney University, won a Rhodes Scholarship, and came here to Oxford, where he became a Doctor of Laws at the University of Oxford. He has become one of the great champions of civil liberties and human rights internationally. He became a barrister at Middle Temple. When I was a young lawyer, I remember being awestruck that he was involved in the Little Red School Book and other very notorious cases. He became a Queen's Counsel in 1988, and he, as I said, is the head of Doughty Street Chambers, where he has provided considerable leadership. Geoff has been leading counsel in over 200 reported cases. I mean, just to explain, that we all do many more cases in our lifetime than that, but for them to be actually reported in the law reports and for them to have made significant change to law is a rarer thing. Many of his cases have been before the European Court of Human Rights, or the House of Lords as it was, which is now our Supreme Court, the Court of Appeal, the High Court, the Privy Council, many death penalty cases, appearances in courts of appeal of Singapore, Trinidad, the Eastern Caribbean, Malawi, Florida, appearances in courts in Australia, of course, his own home country, in New Zealand, in Fiji, Mauritius, and Malaysia, Anguilla, Antigua, and in the Revolutionary Military Tribunal of Mozambique. These cases have almost invariably involved human rights issues and related to international constitutional and media law. And I mean, Geoff has also, as well as doing his court work, he's always been really incredibly active as a writer and as a lecturer, visiting professorships in the universities of Warwick, New South Wales, of Queen Mary College London. He is a really prodigious lecturer as well as a practitioner. He's also been involved, and we've drawn him into many activities in the International Bar Association and our annual conference. He has given lectures that are too lengthy for me to note. He's been a consultant to the Australian government on defamation law reform. He led the human rights missions for, from Amnesty International and back in the days in South Africa, Vietnam, and other places, and in Czechoslovakia. What can I tell you? I mean, I think one of the major things is that you were involved, you were retained by the government of Malawi to advise on the prosecution of Hastings Banda and others. You were appointed by the government of Trinidad to draft the Green Papers on the reform of media law. And you were appointed as counsel to Lord Mackay of Clashfern, who was our Lord Chancellor, in the inquiry into the Commission into the Administration of Justice in Trinidad and Tobago. And you were an appeal court judge in the UN Special Court for Sierra Leone, and were headed that court for several years. And you've been with the United Nations as part of the Internal Justice Council. So you're a trustee of the School of Oriental and African Studies, and still are, and a trustee of the Bureau of Investigative Journalism. Lots and lots of books. Wonderful writer, and your recent book is one of the things that we've got you here to talk about today, because it is your autobiography and it's about your life in the law, but it's really about being a human rights lawyer, being a lawyer who's actively engaged in changing law for the better around the world and taking on some of the most difficult cases. And, acting in cases like, sometimes acting for, you're not always acting for the people that the world likes, but you're making sure that they get proper trials. People like Gaddafi in the Gaddafi libel action, people like Berezovsky, but also doing incredible cases like the Tasmanian Aboriginal Centre's case against the Natural History Museum, which was about the museum's retention of human remains. Many different criminal trials, the Matrix Churchill case. Some of you are too young to remember some of these cases, but they were part and parcel of the great sort of move towards human rights law and protections into the 21st century. Dealing with the blasphemy case that for gay news, the National Theatres case, which was the Romans in Britain prosecution. I do hope you tell that story while you're here today about being involved in that one. Acting for Salman Rushdie in the sedition case, acting for Shaler, who was charged with breaches of official secrets, and representing ITV in the Hutton inquiry. I could go on, but Geoff has written screenplays, he's written wonderful books, and he has been an absolutely amazing barrister changing our world. So Geoff, please, over to you. Welcome to Mansfield College and to the Institute of Human Rights.
Thank you so much, Helena. Oxford won't be the same without you.
No, it won't.
The last time I was introduced by someone with a pronounced, even more pronounced, Glaswegian accent, he said to the audience, "I want you to welcome a distinguished liar." Well, your overkind introduction blows me away. I'm here because I've written this autobiography, which is available at a snip downstairs, and I'll sign it for you. It's an enormously egregious exercise to write an autobiography. I had a client, Julian Assange, who, when he read his own, was so appalled that he refused to allow it to be published. His ghostwriter came back to haunt him. But I thought, having reached the age of 70 years, the Bible's estimate of sentient life, that I should dabble in trying to explain or to understand some of the things that have affected my own life. I'm in my anecdotage, and so why not? I am inspired, of course, by that extraordinary man, Donald Trump. He is so inspiring to those of his own age. Think of all the things he manages to do. Dreadful harm, of course, but at least he does things. So at the age of 71, I am inspired, new inspired. It's a story of a kid who grew up in the outer suburbs of Sydney, a bit like growing up in the Isle of Wight without the pop festivals. And it was as repressive, even more repressive, I think. I, at the age of 7, developed my first political instinct as a result of the visit of the young Queen to her Australian subjects. We were royalty mad, and kids, tens of thousands of them, were crammed in the Sydney showground on a day of 100-degree heat. And it was my first experience of torture, although I wouldn't put that word to it, as kids all round were collapsing with sunstroke or clutching diarrhea-racked little stomachs. And we waited for 4 hours until this car came out and whizzed round very quickly, whizzed round the showground. We didn't even get a wave. And it made me think, why go crazy, particularly Australians, for this royal family? The Prime Minister was an Anglophile named Sir Robert Menzies, and he welcomed her with the words, "I did but see her passing by." and yet I'll love her till I die. Well, I did but see her passing by, but so quickly it made me a lifelong Republican. My wife, Kathy Lett, and I do occasionally get invited to Buck House, invitations which we graciously accept, and Republican, some right-wing commentators in Australia criticize us when our presence is published for betraying our Republican beliefs. They don't understand, of course, the virtues of politeness or Kathy's point about going to Buckingham Palace. Of course they're dinosaurs, but who wouldn't want to see dinosaurs in their natural habitat? Well, that was my upbringing. But what brought me from the Sydney suburbs to the Old Bailey was a stupid act of censorship. In 1960, after the acquittal of Lady Chatterley's lover at the Old Bailey, everyone assumed that Menzies, because he was such an Anglophile, followed everything Britain did, would allow, very strict censorship, would allow Lady Chatterley's lover to come into the country. Well, he stormed into the cabinet room after reading it and said, "I am not going to allow my wife to read this book." At least Australians didn't bother about their servants. But he banned it, and because everyone was in terror of Menzies, they banned C.H. Rolfe's little transcript book, The Trial of Lady Chatterley. Can you imagine banning a transcript of a court case? Well, there was a courageous Sydney bookseller who got his friends in England to write every word of The Trial of Lady Chatterley on those aerograms. You may remember those big blue things, and they were smuggled in as personal mail to Australia, and they were reconstituted, and there was a samizdat edition of The Trial of Lady Chatterley, which fell into my schoolboy hands. Avid for anything about sex, of course, but in fact blown away when I read it by the trial tactics of Gerald Gardner and Jeremy Hutchinson, the great QCs who appeared for the defence. And so it became my ambition, out of Sydney Comprehensive at the age of 16, to appear at the Old Bailey. And of course, I managed to get to England in time to have Gerald Gardner, who was one of our witnesses for Spycatcher, making affidavits against the Thatcher government attempt to ban that book, and to appear with Jeremy Hutchinson in cases against the security service, and one that was mentioned in support of the National Theatre. So to that extent...
Can everybody hear?
Is my...
When you put your head down, it's very clear. I just wondered if when you were looking at...
And I'm talking up. Okay, yeah. I'll put my head down.
No, don't put it down, just...
So I finally made it to the Old Bailey. And I'll never forget my first case. It was to appeal the conviction of the wearer of an indecent T-shirt. And it fell to me, I still had an Australian accent, you know, the nasalized vowel sounds. Private Eye described me as an Australian who's had a vowel transplant. But I did say France and branch. And anyway, I had to get up before this terrifying, sarcastic, reactionary judge and explain what the case was about. And I said, "My lord, this is an appeal against conviction for wearing an indecent T-shirt. The logo is fuck out, let's dance." There was a terrible silence. And suddenly a judicial boom, "Fuck out, let's what, Mr. Robertson?" I said, "Dance, my lord, dance." Another silence. "Oh, you're an Australian. What you'll have to learn if you want to succeed at the English bar, Mr. Robertson, is to say, fuck art, let's dance. And there was a lot of sycophantic laughter, and Justice Melford Stevenson was so pleased at himself for humiliating another young barrister that he acquitted my client. Well, I came to the Old Bailey via a Rhodes Scholarship, and it was very exciting, I thought, very prestigious to win a Rhodes Scholarship to get to UNIV, along with Bill Clinton back in 1970. We never thought Bill Clinton would amount to much. The Middle Common Room voted the American most likely to succeed as Paul Gambaccini. Seriously. But the thing that I talk about in the book, because it's not talked about, and Rhodes House has a kind of omerta over it, is the Great Rhodes Scholars' Revolt of 1970. When we got to Oxford, we discovered the Rhodes Scholarship had been going since 1903. We were in 1970. There had never been a black Rhodes Scholar from South Africa. Never. Despite the fact there were 9 scholarships a year awarded from South Africa and another 4 from what was then Rhodesia. Never a black, never even a coloured Rhodes Scholar had. And this struck us, it hadn't struck anyone else, as appalling. There'd never been a black selector of Rhodes Scholars. And the trustees and the sort of people who got on Rhodes Scholar Trust boards just had no concern, no moral concern at all for this. Well, what we did, and it was thanks particularly to the lead of a couple of American Rhodes, I was there as really the publicity person writing articles, we revolted, and 85 of us, 85 Rhodes Scholars, promised to give back their Rhodes Scholarship unless the Trust promised us that there would be black Rhodes Scholars. The Beatles, by giving back their MBEs in protest against Vietnam, had perhaps encouraged this gesture, but it was serious, it was solemn. I was 6 months into my scholarship, I was prepared to walk away because this was so outrageous. The trustees, of course, were humiliated, were embarrassed, did make those promises. And finally, a few years later, the first black Rhodes Scholar from South Africa came to Oxford. It's amusing, I suppose ironic, to look back on that passionate year when we were rushing through the rain to smoke-filled Balliol common rooms, decrying the racism of the Rhodes Trust and its South African connections. None of us, I don't remember anyone, actually sort of thinking that, well, there is another class that have never had a Rhodes Scholarship either. No one thought of black or white women. That was beyond, I think, beyond our ken in 1970. Came about in 75 when the law was changed and the Rhodes Will was overridden by legislation. But it was a long time before we got the Black Rhodes Scholars, who I'm pleased to see ran the Rhodes Must Fall campaign a couple of years ago. If we want to talk about that, maybe I'll leave that till later. I won't introduce controversial views at this stage. But I went on to do a very strange case, the Oz trial, and then to defend Peter Hain at the Old Bailey. And soon I was fully equipped. 36 dinners we had to eat to become a barrister. Fortunately, Arthur Scargill had struck, the miners' strike, reduced them to 24, so it wasn't so bad. And I became a barrister, and I went along to Eden Ravenscroft to get the wig, the gown, the pantomime flummery that you get as a barrister. Very recently I appeared in wigs and gowns with Amal Clooney at the European Court of Human Rights, and it was a very serious case about genocide, and every newspaper sent their correspondent, their fashion correspondent. And Amal was asked, of course, where she got her uniform, and she said Eden Ravenscroft, a couturier unknown on the catwalks of Paris. But they took photographs, and I made my entry into the BBC's trivia quiz as a bonus point. Clive Anderson, an old friend of course, says for 2 points, what was Amal Clooney's maiden name? And for a bonus point, what's the name of the old guy beside her? So we tried, I think in my early days, to get rid of the pantomime flummery, the wigs and gowns, and it didn't. The Bar Council thought about it and then said, well, we'll have to take a consumer survey, have to take a survey of your clients, the criminals. And of course it came back, they wanted us to keep our wigs and gowns. I like my brief dress proper, they said. So there we were. I entered the Old Bailey robing room, the holy of holies. I was taught by John Mortimer how to insert my wing collar into my shirt, just so as to avoid pressing too hard on that gland in the neck just above the carotid artery. If you do press too hard, this is the greatest danger a barrister in Britain faces in the robing. If you press too hard, it will cut off the blood supply to the brain and leave you gasping for breath, if not dead. And always helps to defend a strangler. He just pressed a little too hard, ladies and gentlemen. But we survived, and I think the only case, wigs and gowns have gone out of most courtrooms, but the only case where I think I appreciated wearing a wig and gown was in the first prosecution in Britain of the movie Deep Throat. And it had been smuggled into the country, and it was prosecuted for indecency and indecent importation. And in those days, it was a sex case, so it had to have an all-male jury. Really, and in the 70s, we had all-male juries for sex cases. And the prosecution opened the case very fairly. You're about to see a film, ladies and gentlemen. It'll be for you, gentlemen of the jury, it'll be for you to say whether it's indecent or not. So the lights in the courtroom went down, and then Ms. Lovelace flashed onto the screen for the next 90 minutes. And 90 minutes later, the lights went up. Nobody moved. The judge made his exit in a crouching position. And the 12 good men and true, they just stayed there. They couldn't move. And the old lady usher said, come on, it's lunchtime. They still didn't move. Come on, I've got to get me lunch. But still they wouldn't move. Those 12 good men and true. And we lawyers, we counsel, put our robes loosely around us, thinking that perhaps there was some point. And you'll never believe this, but nothing I say is untrue. It was a hung jury. A well-hung jury, as we say. So the Old Bailey was full in those days of sex, obscenity cases, blasphemy cases. I acted for Gay News in the blasphemy trial. I shared a room with Emlyn Hewson, actually, who was, of course, the Jeremy Thorpe's opponent in the Liberal Party, and rather he was very nice, very Welsh, very naive. He kept asking me because he thought, because I was acting for Gay News, I'd know. How do they do it? He'd say, what's the purpose of giving Scott a book? What do they use the book for? Giovanni's Room, if you remember from the film. That was, and a period in which there were all sorts of extraordinary cases. But and the bar in the 70s was quite extraordinary. It was unbelievable, the kind of sexism, racism, classism that we had to cope with. There was, women were always barred from chambers. We don't have the toilet facilities, the clerks would say. But now I had to provide unisex toilets, which is the next step. But, and black counsel were confined to what was snappily called ghetto chambers. Seriously, that was what they were called. And it was, of course, the bar was confined to men from Oxbridge who cloned themselves, who just looked for their qualities and their backgrounds in people they took on for chambers. And there was a little group of us who met in various bedsits in North London in the 70s to try to change this. Stephen Sedley, who I'm delighted here, was our intellectual leader. Helena was there, and in 1978, Helena wrote, would you believe, the first article, it was a chapter of a book, about the discrimination against women at the bar. The first article in 1978, when it had lasted ever since women were allowed to become barristers. And so it was a long fight, a long fight. The bar in the 70s was unrecognizable as the bar that it is today. It was, and I talk in the book a little about starting an international human rights practice. In Australia, I'd been much concerned about the death penalty, which had survived until the late 60s. In Britain, there was no death penalty, except in this strange court, the Privy Council, where the final court of appeal for a few dozen countries of the Commonwealth, even Australia until 1986, were the English law lords translated to the Privy Council and having the final appeal for men who had been convicted of murder and automatically sentenced to death. So it was a difficult time. Death row lawyering went on in the Privy Council. And of course, the problem for death row lawyers is that you cannot, by law, change the death penalty. If a country preserves it in its constitution, if its people vote for it, then there is nothing the courts can do other than make it very difficult to carry out. You can't, reason gets you nowhere. In America, of course, the states with most executions are Texas and Florida. They're the states with the highest murder rate. But logic gets you nowhere. You have to face. And what was so tragic, I think, in a way, in the Caribbean, is that all these countries inherited from their colonial masters the way of hanging that Britain had pioneered over the centuries. The whole obscene ritual, the reading of the warrant, the offering of a free last meal, the weighing and greasing of the trap, the execution always at dawn as the sun rose, the official party sitting for an hour around back, the hanging corpse. The burial had to be buried within the grounds of the prison. Why? In an obscure Home Office memorandum explains, this was always done in Britain, because hanging elongates the neck. We don't want the relatives to see the elongated neck. And so in Jamaica, in Trinidad, and the death rows that I visited, they were always buried in the prison garden. And they boasted of their vegetables winning the prizes in Jamaica. That was the death penalty carried out exactly as it had been described, as it had been developed in Britain. And when I went to these death rows, it really came home to me what an awful, torturous place it is. They were in small cages, monkey cages, 6 by 8 in the Royal Jail in Trinidad. They had, if they were lucky, half an hour exercise a day, but the rest of the time had to be spent in these close quartered with men screaming and shouting, this cacophony. It was always, and the prisoner who changed everything for me was a man called Michael X. He was a Black Power leader in Britain of a kind, and he had ended up on death row. And I spent 3 days with him, and I said to him at one point, this is really a place of torture. The noise, the oppression, listening to other men's warrants being read, listening to the sounds that preceded their execution. And I'll never forget, put his fingers to his lips. He said, just listen, listen. So I stopped talking and looked around, and every one of those men was pressed against their monkey cage, trying to listen as I was elaborating a theory that had just struck me. Why don't the Constitution of Trinidad permits execution, but it also prohibits torture? I said, this is a place of torture. Why don't we argue that a prolonged stay on death row amounts to torture and your sentence has to be commuted? And Michael said, you must make that argument. Not for me, because they're going to kill me, but for them. And so we did. Michael was taken off at midnight. He was executed at midnight, first time ever, because they were afraid that we might get to a court and get a last-minute reprieve. But 20 years later, in the case of Pat and Morgan against Jamaica, we succeeded in getting the Privy Council to accept that a prolonged stay on death row was mounted to torture and required commutation. So the death row phenomenon that I had apprehended back in 1975 with Michael X was finally a part of the law, and hundreds of men, I'm delighted that other barristers from Doughty Street have had it accepted in Africa, or even in Zimbabwe. You can't be executed if you spend more than 50 months on death row. So that really interested me in the way in which the Privy Council, through its death row jurisdiction, was developing a kind of international law for the Commonwealth, for Commonwealth countries. And I did then start taking my silk gown, and when I got it, and my wig, around the Commonwealth and around other countries to see what could be done with the developing international human rights law. It is a prerogative of being a British QC that you can gain entrance to other countries. And so I was able to appear in Singapore, which was an extraordinary appearance, against Lee Kuan Yew in favor of his enemies. And it was very difficult, almost impossible, to win a case in Singapore because Lee Kuan Yew would appoint the judges, make them the best paid judges in the world. They all got over £1 million. And of course, they never found against Lee Kuan Yew or his government. There was, I did libel actions against him, and the judge would always increase the damages on the grounds that my cross-examination had hurt Lee Kuan Yew's feelings. The Malaysian Bar Council put out a statement saying this is the first evidence we've had that Lee Kuan Yew has any feelings. But, and I acted for the detainees. And in one case, one extraordinary case, the only case in Singapore history after Lee Kuan Yew, where the government lost. Habeas corpus, they had detained for 2 years some lovely, idealistic Catholic workers, lawyers, a couple of women playwrights accused of exaggerating the problems of the poor. And they'd been kept in detention for 2 years on detention warrants. And I took the point because it was unarguable that the law required the detention warrant to be signed by the minister. These warrants had been signed by his permanent secretary. So there was no way, if they wanted to be regarded internationally as judges, that the Court of Appeal in Singapore could deny habeas corpus, clear as daylight. So we won. It was an amazing day. All the parents went out to the prison to wait for their children to be released. The kids were in their 20s mainly, university students. They were allowed to pack up their pictures, take their books in suitcases, put on a bus. It was the Whiteley Road Detention Centre. It was up a hill. And the bus left the centre, down the hill, through the gates, surrounded by cheering parents and friends, out onto the road, around a roundabout, up through the gates again, back to the prison where they were presented with warrants, detention warrants, fresh detention warrants, signed by the minister. In Singapore, under Lee Kuan Yew, even when you won, you lost. So it was an extraordinary, but the fight was worth it. And even in Singapore, British law and European human rights law could at least be voiced in the courts. The other country I did a lot of work in, although I wasn't admitted to practice, was in Czechoslovakia in those extraordinary days in the 80s, where Charter 77 and those amazing dissidents, really proud and important dissidents led by Václav Havel, stood up to the Stalinists who were in government. And of course, it was Kafkaesque, as you can imagine. I took Václav Havel to lunch at a restaurant, and as everyone else did in Prague at the time, paid, or was about to pay, in American dollars. And he said, no, you can't. Look, I'll be arrested. But I said, everyone accepts American dollars with alacrity in this city. He said, no, you don't understand. The first rule of being a dissident is you must scrupulously obey the law. So it really was extraordinary. But in those days, it was the Stalinist government was prosecuting the Jazz Society. I said to him, well, why do Stalinists hate jazz? And he said, because it's music you can talk under. And of course, people did. And I mean, I don't much like jazz. You think it will turn into a tune, and it doesn't. But the Jazz Society was accused, and very cleverly, they were being prosecuted not for sedition, which was their real crime. They'd been linking up with groups in the West. They'd been honouring John Lennon and so on. No, they were being prosecuted. That was the real reason, but cleverly they were prosecuted for fraud, for taking money for their concerts. But of course they were a non-profit-making society, so the charge was nonsense. But it played well to diplomats. Oh no, we're not prosecuting them for their music, we're prosecuting them for fraud, a crime in your country too. So that was the trick that was used in the 80s. And I went with Havel to the sentencing of the Carol Serp, who was the head of the Jazz Society, and it would have been 7 years if we hadn't kicked up an international fuss, and involved UNESCO and so on. But he got 2 years, and as we walked out of the steps at Charles Square, there were about 200 supporters who broke to a ragged chorus of "We Shall Overcome." And I said to Havel, it's very heartening that we've got some young support. He said, yes, and on these occasions, you can always tell who are the secret police. They're the ones who know all the words. So, anyway, that was my introduction in the 90s to international human rights law. In the book, I do, of course, deal with other cases. The one everyone seems to want to hear about is, I'll read a little of, the most bizarre and most publicized of my cases came in 1995 after a world exclusive in the Sunday Mirror 2 years earlier. Die Spy Sensation, the most amazing pictures you'll ever see. The photographs, spread over 7 pages, were of Princess Diana exercising on a contraption called a leg press, taken by a camera sneakily hidden in the ceiling by the gym owner, Bryce Taylor, an impecunious New Zealander. The princess, out to prove herself after separation from Charles, was advised, badly as it turned out, to go down in British history by issuing a novel action which would create a hitherto unrecognized civil wrong, invasion of privacy. The High Court judge who first heard her claim thought that such a dramatic change in the law should at least be contested. He extended legal aid to Bryce and asked me to represent him, which would mean cross-examining the People's Princess. A mock-up courtroom was constructed at Kensington Palace so she could prepare for my cross-examination, and 940 journalists applied for the 75 press seats in court number 36 of the Royal Courts of Justice. The courtroom artists, who produced what were meant to be accurate portraits of court proceedings, but who were banned from sketching in court, had already painted our encounter. I was depicted, all jowls and splutter, pitted against the Queen of Hearts, radiant in the witness box. I prepared for this case by doing something I'd avoided throughout my life, joining a gym. I even learnt to cardio funk, an exercise that Diana had been doing at Taylor's gym, which, quote, combines funky dance steps with aerobic moves set to hip-hop music. I avoided her choreographed colonics, but learnt the art of toning my buttock muscles on instruments of torture called the life cycle, the rotary torso, the lateral pull-down machine, and the Concept 2 rowing ergometer. As the tabloids rejoiced, salivated in fact, over the upcoming courtroom clash, the establishment was wary. The Times described me as, quote, anti-establishment, Republican, and Australian, presumably in ascending order of horror. Journalists doorstepped my parents at our Sydney home. What advice would they give the princess? I would settle the case out of court, said my father. And so she did, the evening before the trial of the century. There was a deal, and her lawyers withdrew her claim after depositing $1 million in Bryce's Swiss bank account. This was all swathed in secrecy. Of course, so the princess could claim to have won, although it was an odd sort of victory where the loser was rewarded with a sum greater than the winner had claimed in damages. I cancelled my gym membership, forgot about cardio funk, and moved on, somewhat deflated, as always, when a big case settles at the door of the court. It's a condition my wife calls cortus interruptus. And then, of course, the Human Rights Act came into force. We'd had arguments, particularly with Stephen, in the years in the 70s and 80s over whether judges could be trusted with the Human Rights Act. And when, of course, the Human Rights Act came in, it was Stephen was the judge whom they trusted to teach the other judges how to deal with it. But in the year 2000, the Human Rights Act came into force in the United Kingdom, and to national astonishment, its first beneficiary was the American boxer Mike Tyson. He was the youngest ever heavyweight champion of the world at the age of 20 and a convicted rapist a few years later. In 1995, aged 28, he was released 5 years later, out to regain his heavyweight title from Lennox Lewis. Tyson fought about in Glasgow with American Lou Savarese on a freezing night in a hall packed with Scots baying for blood. It wasn't long in flowing. After 12 seconds, Tyson floored Savarese, who went down for a count of 8. "Fight on," said the ref unwisely. Savarese could barely stand. Tyson landed a left hook that shook him, and then, quote, "as every good boxer would be trained to do in these circumstances," I found myself later telling the tribunal, went in for a knockout. At this point, the ref interposed himself and claims to have said, "Stop boxing." But then, as a result of what I later described as inadvertent contact with Tyson's upper arm, the ref himself went down, and Tyson kept hitting his opponent onto the ropes. After just 38 seconds, the fight ended, and the shaken referee declared Tyson the winner. As microphones were pushed in his face, the victor made some comments which were alleged to be, quote, "detrimental to boxing and to the public interest." Tyson was hauled before the British Boxing Board of Control, and the media had no doubt the board's intention had been leaked, that his license to fight would be cancelled, he'd be disqualified from title fighting Lewis. The case required a delicate examination of the role of hype, which had come to infect this particular sport, an expectation by promoters that boxers would sledge their future opponents to whet the bloodthirsty appetites of potential audience and thus swell agape their profit from the event. It had, in a way, started with Cassius Clay, otherwise known as Muhammad Ali, but his promises were poetic: to float like a butterfly, but sting like a bee. Tyson's declaration was, "I'm coming for you, Lennox Lewis. I'm going to rip your heart out and eat your children." My first offence, as reported in the press, was, since Lennox Lewis has no children and boxing gloves do not rip through flesh, this comment is ludicrous and fantasized. Not even the law's measure of naivety, the moron in a hurry, would take it seriously. But this argument didn't seem to be convincing the tribunal, so I rolled out the new Human Rights Act, which had to be applied to all public bodies, including the British Boxing Board of Control. The Act gave particular importance to freedom of speech, which could only be curbed in the interests of public safety or preventing crime, not in the interests of boxing. To take away Tyson's livelihood and his chance to regain his title, punish him for exercising his free speech right to make tasteless remarks about a future opponent, would not only be unlawful, but could open the board to a suit for damages. Besides which, Tyson's remarks were, I said, quote, "an ironic response to racist stereotyping. You treat me as if I were a jungle savage, so I'll play along with your stereotype. Here, I may have misattributed a degree of sophistication to my client. The truth is that he was so pumped up with adrenaline that in the few minutes after being declared victor, he could have said anything. That's why there's a rule. Radio and television interviews with boxers are not permitted in the ring following a contest, a rule that the steward on the night had blatantly breached. Well, the case went on into the evening, and the board came back with merely a reprimand. I could not tell which argument had convinced them not to cancel Tyson's boxing license, although the press reports of their decision were headlined, "Tyson lands human rights uppercut to boxing board." Thereafter, the act would benefit many more worthy clients, but the case did make the point that human rights are for everyone, the good, the bad, and the ugly. Let me say a word about the current problems of the bar, because you may have read barristers going on strike. I think, and you may have read also, about the number of wrongful convictions that have come about, particularly in rape cases, but not only in rape cases, because of the failure of prosecutors and policemen to make important material available to the defense. Now, this particular issue came about in the mid-1990s as the result of several IRA cases, which were in fact wrongful convictions where the police had not made available evidence. The Guildford Four was one. And because of an extraordinary case, which I did call the Matrix Churchill case. Barristers are often asked, how can you defend someone you know is guilty? And the answer is you sometimes really don't know. And I quote this case of Paul Henderson, who was the director of a machine tool factory that made arms. These machine tools he sent off to Saddam Hussein just before the first Gulf War, and they made machine tools that had killed British soldiers in the course of that first war. And he came to see me. I got the prosecution papers. They were voluminous and they were devastating because they showed he'd made false declarations to customs. And that was what he was charged with, 7 years in prison. And I said to him, how can you possibly plead not guilty? And he said, well, actually, I was told how to make the entries by Alan Clark, who was Mrs. Thatcher's trade minister, and I reported every time I returned from Iraq to MI6. There wasn't a skerrick of evidence of this in the prosecution papers. And I said, well, if this, which seemed a fantasy to me, if it's true, there will be documents in MI6, in the Cabinet Office, about it. Alan Clark had signed a statement saying that he'd never met Clark, and it was extraordinary. And so we embarked on a massive disclosure exercise. And do you know, of course there was evidence, and of course it was exactly as Paul had said. He had been thrown to the wolves by a government that didn't want to admit its role in arming Saddam Hussein. They were happy for Paul and his co-directors to go to prison for a few years to save their embarrassment. And do you know, the Conservative Attorney General, Nick Lyle, insisted that the four most senior cabinet ministers should sign PII, Public Interest Immunity certificates, to keep these documents from us, so we could never have a defense, a true defense, that Paul had been working for MI6 and had been shown how to make the false declarations by Alan Clark. And Ken Clark, Malcolm Rifkind, and a couple of other ministers signed those certificates. You know the one person who refused to do it? The one minister? Michael Heseltine, the only one who wasn't a lawyer, the only one who wasn't a QC, refused to sign for fear of putting an innocent man in prison. And that just shows you, if you can't trust QCs to know, to see evidence that will support the defence, who can you trust? Policemen, prosecutors? Of course not. But it happened, of course, that Alan Clark was called to give evidence. And John Mortimer always taught me that the art of cross-examination is never to examine crossly. And it's so right, you know. We had an hour or two to get to know each other, and then Clark admitted that he was a snob, so he wouldn't admit that he lied, and he was a particular snob, so he wouldn't admit, as the Cabinet Secretary had in the Spycatcher case, that he'd been economic with the truth. He said, I was economic with the actuality. And the case collapsed, of course, it was withdrawn, and the government survived a no confidence vote and it was the beginning of Tory sleaze that led to the Blair election. But the interesting thing, of course, it led to a massive concern about police and prosecutors not disclosing to the defence evidence that is supportive of the defence case, because how would they know? I participated in some of the debates at the time, and with a sort of mantra, only the defence knows what is supportive of the defence. And yet we were beaten. The government, persuaded artfully by prosecutors, did not bring in what Lord Justice Scott, who conducted an inquiry into the Matrix Churchill case, suggested of a right in the defence to inspect the prosecution papers. He brought in a law, the 1996 law, still there, that said, the prosecution must disclose what is, in its opinion, supportive of the defence. It left it entirely to the prosecution to decide. And this is the problem. This is where cases have gone wrong. Because look, in the mechanics of a criminal trial, the police are totally get caught up with the suspect. They believe the suspect is guilty, which is why they put him or her on trial. They don't read all the additional material, and if they do, they don't see aspects that are supportive of innocence. Sometimes they're simply too lazy. Sometimes they're just blinded by their belief in guilt. Prosecutors, too, don't know what the defence will run. They can't think creatively of what may gel with. And, of course, in these rape cases, you do get awful lot of text messages that have to be gone through, and that sometimes are completely antipathetic to guilt, that sometimes they really prove that there was no force, no overriding. So that is why there have been so many miscarriages of justice. The head of the Criminal Cases Review Commission suggested the other day that there had been hundreds since the 1996 law, which failed to make it a right for the defence. So that is one problem that really must be addressed before we have other wrongful convictions. There is a graver one, arguably, I think, and it's this. The lot of a criminal barrister is underappreciated as well as underpaid. And it's underappreciated because people don't realise what life was like before the legal aid system was brought in. It was one of the great Beveridge-induced reforms of the Attlee government, but along with the National Health Service. And legal aid is something we should be as proud of as we are of the National Health Service. before legal aid, you had the doc brief system in which barristers would be paid a guinea for defending a poor person. And as the poor person was brought into court, you would see all the barristers who were any good disappearing, not wanting to have a guinea for what could be a week's work. And I think it was Terence Rattigan who really illustrated in his play The Winslow Boy, which was about the Archer She case, how a family could be destroyed, a middle-class family would be destroyed by the lack of legal aid. So we really should think of legal aid in the same sense as we think of the National Health Service. But more money for nurses is far more palatable than more money for lawyers. And lawyers in the criminal world, I think the commercial lawyers are doing very well out of Brexit, and even more out of all the bankruptcies that will come as a consequence. But it's sad that some of my young barristers have to fork out to pay their train expenses and so on for defending people are more than they get from legal aid. We've allowed legal aid to dwindle so as to discriminate against the criminal bar, to make diversity more difficult, and so forth. So without making a plea for criminal barristers, I am just concerned at the moment that we're getting a little out of whack. I'm going on and we need to talk, so I will just say that I'm concerned, and I've explained in my book, I've tried to say a chapter to defend Julian Assange. I think he's a man who, of some courage, a man who's been vilified in this country by people who should respect him, by journalists. They write horrible things about him. They say, oh, he eats with his fingers. He's an Australian. We do barbecues. They do not understand in what dire peril he is. He's been in effect in prison for 6 years. We're going up to the 6th year. And he's done more than anyone else in the world to illuminate how power operates. And I saw him the other day. He's vulnerable to changes in power in Ecuador, and he has had cut off his internet, his lifeblood, really. He can't send or receive messages. He really now is in prison. And the Trump administration, both the Attorney General and the CIA director, have said his prosecution is a priority. And there's a sealed indictment where the charges against him add up to 45 years. And they want Bradley Manning, Chelsea Manning got 35 years in a supermax. Obama came to her aid after a couple of years. That mercy won't be extended to Julian Assange and Trump. Lawyers have come up with this idea that the First Amendment, the great protection of the press, does not apply to non-American citizens. So they can get Julian Assange and many others. So that is a matter that concerns me. The other thing in my book is, well, where are we going? What has happened to international human rights law that looked so good, the Nuremberg legacy, and is now seems so vulnerable? That was the case with, in 2011 it looked good, but then came Assad, then came, I wrote an article in 2011 after 800 people had been mown down in Syria, saying this amounts to a crime against humanity. Nothing was done. The Security Council did not lift a finger. Now 400,000 people have died, 5 million have been dispossessed. The Security Council is polaxed. Russia, China have vetoes. Nothing can be done, except, I suppose, in states which have no superpower support. Well, this is leading to an idea that we owe a man called Bill Browder a lot of credit for coming up with. This is the idea of...
Bill was here 2 weeks ago. So
oh, right. Well, you know all about Magnitsky laws. Sergei Magnitsky, the lawyer, tax lawyer, who blew the whistle on the attempt to raid Bill's company, thrown into prison by crooked judges, crooked policemen, beaten up and killed. And the Global Magnitsky Act passed by Obama, which at least included judges as well as policemen among those human rights abusers banned from America. Now, we have a sanctions bill, a Sanctions Act, just been passed, and it gives us the opportunity and the power to have a Magnitsky law here. And it's got to go further, I think, than the American law. It's got to stop human rights abusers not only coming here, not only putting their money into British banks, it's got to stop them putting their children into Eton, their parents into Harley Street, their mistresses into Chelsea. I mean, this has got to be a real punishment, and it is something that is entirely a matter for our own sovereignty. So if Bill has spoken about it, I don't need to say any more. But I am optimistic at the end of the day, despite the refugee crisis, despite climate change, despite Trump, that we are progressing and that international human rights law is developing to a stage where at least countries in the West and a lot of other countries, whether they do it for the right motive or not, whether they improve their human rights record in order to get more aid or order to get aid, it doesn't matter that the idea of human rights is improving. Whether it will be so next Wednesday in Singapore is another matter. North Korea may give up its expensive nuclear habit. It will still be the most oppressive society on earth, where you can go to prison for life for not busting your picture of the great leader. Mr. Trump, I don't think, cares about human rights, and that will be a crucial test of whether the world is prepared to go a little further, to think a little more deeply than simply destruction of missile sites. But I've gone on long enough. Thank you.
Jeff, thank you very much. That was really, really interesting. I mean, you've had the most extraordinary career in the law, because it hasn't just been that you've done extraordinary cases here in Britain, but you've also done really remarkable cases around the world. I wanted to take you back to the Matrix Churchill thing, because there'll be some of the young in this room will be completely unaware of that story, because it is a remarkable story. Which was that there we were, we embarked on the first Gulf War because Saddam Hussein had invaded Kuwait, and this expansionism was worrying folk in the region, and so the United States and the UK became embattled with him, and we were rather duplicitous because we had, as you described, been actually, not just turning a blind eye to the sale of what were components of weapons to Saddam, but we're actually using the people who were doing it in order to get a certain amount of intelligence and employing him. But when it became revealed that there were companies who were in breach of law, and it wasn't known that they'd actually been working for MI5 and that they were doing it in cahoots with the government, and one would have expected that was the moment at which the government would have put its hands up and said, look, we were behind all of this because we wanted information, and that's an essential part of, you know, how the world operates. But instead of doing that, they kept their heads down and expected your client to keep his head down, and that nobody would believe him if he did say that he'd been working for MI5. We often have clients, it has to be said, we often have clients who say that they were working for MI5. It's a common defence. I was working for MI5. But, and then it became clear that he had been working for MI5, and he had been doing that, and he had been tutored in how to make the kind of false applications when they were going to be in breach of the rules. And what seemed to, I mean, one of the things that was so shocking about all of that was the extent to which government was prepared to basically throw them to the wolves. And I remember that you were in it, and Ken MacDonald was your junior in it, who became the Director of Public Prosecutions.
Now the Warden of Wadham.
And and I remember a meeting in Chambers. I remember Robin Cook coming after the trial had all been over. I knew Robin, and Robin was the opposition a person who was leading on foreign affairs, and he came because he wanted to fully understand what were involved in, you know, who knew about this stuff, about what were these certificates, the immunity certificates were about, and they'd been signed off. And I just wanted to test you on this. I mean, wasn't it just that they were put in front of people who just signed them because it, or
it may be, but you know, Rifkind and Clark were QCs, mind you. They were QCMPs, which means not.
They've been a long time since
they've
done real law.
It's been a long time since they practiced, but they still used the title, and it was, I think, a question where
added momentum.
It's Nick Lyle I particularly blame, and he was the nicest possible person. Nick Lyle QC was the Attorney General.
That's right.
And but it was almost a knee-jerk reaction. This is going to cause us enormous embarrassment that wretched Alan Clark encouraged them to sell bomb-making equipment to Saddam Hussein that did kill British soldiers. So
but you were involved in other cases like that. There were a set of cases that happened in the 90s which really shed appalling light on conduct of government. One of the other cases, so you were involved in that one, which really did expose the government to a huge amount of criticism. And this was all building up, in fact. And I mean, we were talking about an end of a period of extensive, it was during the major period where everything was beginning to crumble after the Thatcher years. And then you were involved in the business of which was an extraordinary case where you managed to get documents that were very helpful in the case against Jonathan Aitken. Do you include that in the book?
Yes, that was The Guardian.
Yes.
Yes. Oh, yes. I mean, in disclosure is probably the defence lawyer's greatest attribute and art, to get the other side's documents, make sure that they're all given to you. And sometimes, I mean, The Guardian, they had to go to spend 3 days in a hotel in Switzerland to get the document that destroyed Aitken's account.
I mean, Jonathan Aitken was in cahoots with the Saudis and was doing arms deals and things there, and making money out of it. And he'd had secret meetings in Paris with Saudis to do these deals.
He got his daughter to lie.
And his wife.
For him, and particularly his young daughter.
His daughter was was not an adult.
That
and
was
signed
dreadful.
statements.
But of course, he's now a prison chaplain, and so he's going to heaven at long last in his own imagination. But it was. Okay, he raised the sword of justice, if you remember.
Yes, and accused the Guardian of framing him and lying about him. And but you were the person that managed to get a memo out of the Cabinet Office, which did show that actually there was more knowledge about all of that, then...
I think we believe that the British government acts honourably, and it certainly in the Matrix Churchill trial, it was gobsmacking that they didn't. And of course, as soon as they were confounded and confronted, as soon as they had to give up, a judge, we got to order one or two documents and he led on from there. Oh, well, they turned on their head and the MI6 operatives came along and said terribly nice things about my client, and you know, it changed entirely. But the instinct, the knee-jerk reaction was to cover up.
Not
was
to
cover up.
disclose.
And you know, it's awful to make allegations against the police. You see this case of Lust and or is it Lust, the shop that has taken these anti-police advertisements? Sorry?
Lush.
Lush, right. I'm getting
That was a
old.
Freudian slip.
My eyes aren't what they were. But it's a very good example of, I mean, that conduct is utterly obscene. Can you imagine senior police officers authorizing policemen to go and have sex with protesters, have children with protesters? The children arrive, the policemen are allowed to decamp. The first judge who came, who took an hat, of course, said, oh, that's what James Bond does. Can you imagine a judge?
Didn't want to believe that it was possible.
No, he thought it was quite acceptable. I think it's the most obscene thing of all. Our Chambers, I'm pleased to say, has sued Scotland Yard for maintenance, and it's paid up. But it's a pity that the inquiry has been bogged down.
It's incredible that the
years,
public's money is going through via the police. The allocation of funds is paying for children that have been,
and they were only. I mean, these people were what were they? Animal rights protesters or greenies? They weren't. Well, they weren't terrorists. They weren't IRA people. When the odds might be greater, and you might say, well, there is an argument that you should get that
infiltrate.
place.
Yeah. Who would like to come in with some questions? I can see hands and so on. Yeah, there's a gentleman up there. He's got his hand up. Please, can you take the microphone?
The Windrush case suggests that we're a long way from human rights. I mean, it's horrifying, isn't it? The things
the whole
that
business
people
of
have been put
Windrush.
through.
It is. It is horrifying, and I'm not sure as yet whether it's cock-up or conspiracy. I don't know whether it is just massive ignorance and incompetence.
No, it's about a culture that's created.
But it would seem to have been this culture under Theresa May that had developed in the Home Office.
There's nothing new about it under Theresa May. I mean, it may have been in an extreme form on that business of saying we have to create a climate of that was going to be of hostility. But for years and years and years, if you were doing immigration cases, there was this general sense which was that you had to not believe. Your starting point is they're liars. People are going to be applying for immigration status or for asylum or whatever, and they're going to lie to you. And therefore, you start off by not believing. And once you're starting that, it's very difficult if you're, for example, a woman who's been, raped in the Congo and who's reticent about talking about sexual matters, and then doesn't in the first round, but does the second time, is more clear about what happened to her. Then she's accused of being a liar because, she didn't mention it the first time. And so those sorts of things are about a kind of attitude that seeps into the system. Yeah. And so I agree with you. I think it is a grievous and terrible thing, but those things are about attitude. I mean, they really are. There's somebody behind you, unless you want to come in again, sir. No? Okay. Paul Flather, please.
I really enjoyed that, and I also wanted to thank you because you clearly influenced a lot of other people. Besides just making so many precedents, I think it's the kind of ripple effect you've had on other people, which makes it so significant. I did work a lot with Haval, and I think the jazz. I mean, the point that you made was a very good story, but I think more worrying is the metaphor, because jazz doesn't follow rules. Jazz is kind of informal, and that was so annoying to a system based on rigid rules, i.e. Marxism, Leninism, which is out of date. I've got 3 puzzles for you. Number 1, can I as a private individual sue Assad for genocide? Number 2, the European Union in its own legislation says that we should not trade with other countries that break human rights. So can I sue the Commission for trading with China? And number 3, can I produce a league table of barristers who are generous in their pro bono work? I totally agree with you about legal aid. Because we're short of money as a state, we're not going to solve that. But it would be nice if we could publicly praise those barristers who went out of their way.
But can I tell you, I mean, Jeff's not going to want to say this out himself, but one of the things is that if you were to look at the list of people in our chambers, they all do a high percentage but the problem about that is you develop skills in a field. And so to suddenly turn around and say, well, why aren't these commercial lawyers doing pro bono work? Well, and some of them do. But if you don't know a thing about welfare law, and you don't know a thing about immigration law and asylum and so on, and have spent all your days doing, mergers and acquisitions, then you're not going to be much good to the folk that, you build up expertise as a lawyer. And the terrible shame is about all of this is that there just aren't enough pro bono hours that you can put into the number of people who need help.
I accept that, but can't I be praising those who do it? It's not that I'm going to be negative against those who don't.
No, you mustn't praise too much, Humility is a good thing in a lawyer. There's no problem about it.
My wife always said that the words pro bono were the 2 words she least wanted to hear, unless it meant I was acting for an Irish pop singer.
Mr. Bono would have been very happy to have you.
But I think your first question, I thought no. Your second question, yes, possibly. And your third question, of course, was...
But we've all forgotten what the questions were.
Was the identification of the lawyer. And, a lot of lawyers would always say, a lot of solicitors would say, we give so much time to our church, to our golf clubs. They were all acting for their golf clubs. It's more difficult, obviously, to identify those lawyers who do make a real sacrifice. And I think it's invidious. I think lawyers would be, even the good ones, would be unhappy to get on the list of good lawyers. I wouldn't go down that route. But in a way, I think the criminal bar has seen it as a privilege, which undoubtedly it is, to defend poor persons accused of crime, to make real the right of access to the courts. But really they've forgotten to fight their corner. And over the last 20 years, their leaders have simply not murmured as the value of their pay has gone down by 50% and has never been index linked. And I think something as simple as this would solve a problem that otherwise will end up with strikes.
I mean, I just want to say on that one, I'm not prepared to accept that legal aid, the days of legal aid are over. I think one of the problems, and Labour was responsible for this as much as anybody else. Labour started it, and then it was absolutely, the whole business of austerity and the economic crisis gave a great excuse for taking a scythe to many of the things that people didn't want to pay for. But the whole business of reducing legal aid started with people saying that it was part of welfare, that we have to reduce welfare. Access to justice should never be seen as welfare. I mean, access to justice is the same as the right to health and the right to education. And it's so fundamental that this is not about, helping people, having a safety net for people in periods when they're unemployed or whatever. It's about something else. It's about something that's so profound and so needed in a democracy that you have to describe it in another way. And by including it in welfare reform and Labour did that too, then you ended up destroying something absolutely vital to the needs of a society, I think. And so we've got to stop doing that and calling out as welfare. Who would like to come in with another question? Please, Lady Darendorf.
I would like to ask you about the Secret Courts Act, which was passed under the Secret Courts Act, which was passed under the last coalition government with, I'm afraid, the support of Nick Clegg. And I remember Helena's wonderful speech about it. But my question is, are you aware of any egregious abuse of that legislation by the government? Because that was our fear at the time.
Well, you wouldn't be aware, would you? Because it's secret. So we don't quite know. In time, things will leak out. But I was very interested in the fate of that litigation brought by the Libyan, who had been rendered, Belhaj, who'd been picked up in Thailand, taken to the US camp, which should be in a British island in Chagos.
It wasn't in Chagos. He was taken to.
He was, and then he was rendered to Tripoli.
Yes, he was.
But he spent some time at the US base in the Chagos Islands, which we leased to the Americans for a peppercorn rent.
That's right.
Harold Wilson did the initial deal where he got 25% off Polaris in order to give the Chagos Islands to the Americans, and Britain did the dirty work of carting off the Chagosians. But to go back to this particular case, it's one of the rare cases where we have evidence, because we have the letters of this crazy assistant director of MI6, who I'm told Ed was at school with him.
Yes.
Apparently he kept a falcon in his school locker, and so he was always a bit odd. But he was the one who was congratulating Gaddafi and Gaddafi's spy master Musa Kusa on the successful rendering by Britain and then by America of this fellow to torture in Libya. And it was Jack Straw who nodded it through, who approved it. So what a hypocrite, approving the moving to a torture prison of well, he wasn't a British subject, but he was a human being.
But we now do it in another way, Jeff. We're now removing people's citizenship. And by removing people's citizenship and saying you don't belong to us anymore, we then are actually often, they're away, they're out of our hands, but they might be in Somalia, for example. And we then remove their citizenship, people who've lived here most of their lives, because they came for asylum with their families as children. We go through school and everything here. They're out in Somalia. We remove their citizenship, and then they're picked up by the Americans, and rendition takes place, and
they go to Guantanamo. And these two Beatles, we wash our hands. We don't have to try them because we say take no responsibility.
We're not responsible because they're not our citizens anymore.
And it's all contrary to the Convention Against Statelessness, because we render them stateless.
Yeah. So, but they say that they're not really stateless because now Somalia allows for dual nationality, and they just have to apply. There's a hand up there, that lady up there. Please, yes. The microphone's coming in. You are behind glass, so it's harder for us to...
A quick question for you. You've obviously been very effective in being involved in cases where the truth eventually and justice have come out. A current case in North America, which the media is managing to cover, I feel, is the whole issue of 9/11. And about a month ago, there were some lawyers here in London, so I went to the meeting, and 40 lawyers have been working for 2 years pro bono and just launched a case against Saudi Arabia and the US government for controlled demolition of World Trade 1, 2, and Trade 7, which most Brits don't know about and most Americans don't know about. But the biggest challenge is the media, because no one will touch the story. It's looking like an inside job. But if the media won't touch it, most Brits that I talk to here, I'm from Canada, so we host their meetings in Toronto. But most Brits don't even know that, you know, the BBC reported the collapse of World Trade 7 before it happened. How do we manage to get the truth out when the media won't touch the truth?
Well, I think that's a broad question, that you anchor in a particular example. And I'm not quite sure. There have been a number of cases attempting to bring against Saudi, because most of the perpetrators of 9/11 were Saudi, an action for damages. And I think there has been an initial finding by an American judge that the case can go ahead. And my reading of the media at this stage, I picked this up from some obscure American law journal, but my reading of the media is that this is no big deal. It's only a first instance decision by a judge who is likely to be overruled, because any attempt to take a friend of America, to take Saudi Arabia to court in America.
But how likely is that for it to be successful in
will
reality?
Not be successful.
I mean, many Brits commit crimes abroad, and we'd be pretty outraged if we felt we had to pay compensation for everything that our citizens might get up to when they go hither and thither in the world. I think as British citizens, we would feel that if we had to compensate for the bad behaviour of all of our citizens, we'd be in serious trouble. So, you know, I mean, there's a limit on that. And so, I mean, the question would have to be, there'd have to be a nexus between the Saudi government's failure to do something about constraining that kind of conduct before there could be anything successful in terms of litigation. I mean, you know, you'll have a better
Well, there was
sense
an attempt to prosecute Prince Charles, wasn't it, when he went
and that
to
didn't
Florida.
exactly
That
flourish.
No, the White House stepped in and issued the effect of noli prosequi.
Yeah. So, I mean, I don't think that litigation's got an awful lot of you know, likelihood of success. If it's about trying to shine more light on the fact that, in fact, Saudi often is complicit in bad stuff and allows things to happen and allows money to go out from many of its rich inner circle to things that are...
Well, our friend Ben Emerson has just yesterday released a report saying Saudi is as cruel can be.
I mean, about human rights abuses.
Yes, it's not a very good idea. He was allowed in to Saudi Arabia as part of the
UN.
Part of the thaw, as part of their attempt to look better, and he came up with a total
It's really
blackwash.
exposed.
Yeah.
Exposed the extent of the abuses
in
in the prisons,
but
and the lashings and the beatings and the which are sanctioned by law and which they are allowed to take place. So, I mean, you know, shining light into that is very important. But I'm imagining that there couldn't be successful litigation in relation to the Twin Towers and 9/11. I don't see it myself. Who else would like to come in? Gentleman there, please.
Thanks for a great talk. I was in court this morning, and some of the orders that we asked for were granted and some were refused, and in retrospect there were some arguments that I could have put better, and there were some arguments that I should have put that I just didn't make at all. And it occurred to me even before this talk, actually, before I even knew I was coming to this talk, that the stakes are so much higher in criminal cases. And I just wonder, it makes me feel uncomfortable when I know that I've fallen short in some respect, and I wonder how criminal lawyers like yourself grapple with that when the stakes are so high.
It's so interesting, though. I mean, that's one for you. I mean, when you're doing something like death penalty, does it weigh? I mean, do you have sleepless nights? Do you?
Death penalty is due when you're at trial. On appeal, less so. You spend your nights going through those yellowing transcripts of the page after page, trying to find some point on which you can interest board law lords to take it up. I think the criminal barrister must take control of him or herself. Remember when I lost my first client to prison, it was devastating because he shouldn't have gone to prison. That was a particularly cruel judge, and I was very depressed. And I said to John Mortimer, I was in his chambers, I think I'll leave the bar. I can't stand this. And he said, you must never allow yourself to be too emotionally involved with your client. You must have a degree of distance. Now, in this case, I differ from your American lawyer friends, from William Kunstler. I only defend those I love. No, it's more difficult to defend them if you love them. While you can like them, you must keep a level of objectivity, a level of distance. It's not your fault that they've been sentenced. It's not your fault that they were convicted. You've got to do your best, but you can't allow it. I have met a couple of very fine women who ended up in a public defender position defending rapists, and after a while they just couldn't take it. And that was reasonable enough. They should have been moved to other cases because there is a psychological toll that the defense lawyer has, and they do. But all I can say is you've got never to blame, not to blame yourself, but to keep that degree of objectivity and independence. Because I think independence means independence from your client. You've got to be in a position to tell your client you've got no case. You've got to be in a position to say to your best friend, if you like, you've got no case. And because it's your best friend, you'll have difficulty telling. You should tell your best friend to go and see another lawyer. But that's all I can say on that perennial problem.
I have a slightly different view, but we won't go there.
Let's hear it.
Jeff, you may remember we tried about 4 years ago to enforce against Iran for the victims of torture and mass executions against some assets that Shell had of Iran. Do you think the time has come for English law to move slightly along American lines where the sovereign immunity has been waived for in unique and specific areas, in particular, well, in America for terrorism, but in here for human rights violations? Because that seems to me a very powerful instrument, especially when it addresses the individuals who've been responsible for some of these egregious things, but also to hold the sovereign itself liable for the kind of things that you've written about in the past.
Well, it is every form of immunity, whether it's Pinochet's claim to a head of state immunity or ex-head of state immunity, to, we were talking, I think, once about prosecuting an ambassador for Iran, who is quite a big deal at Princeton, but he was the ambassador, Iranian ambassador in Germany at a time when a hit squad came from the government and killed about half a dozen people in that Turkish restaurant. I just forget its name, but yes. And why should an ambassador? He hid the weapons, he hid the assailants. There was radio traffic back to Tehran.
And he got immunity.
And he got immunity, and we could not move against him here. So immunity of any kind ought to be reduced. Of course, diplomats have it sometimes, even for allegations of rape. Certainly for parking tickets, which is America runs up millions every year, American diplomats in London for parking, and they don't pay it, and this infuriates the London Council. But
That's one of the reasons why Trump is at war with our mayor of London.
yes, exactly. So
Because our mayor wants the money back.
whether it's that kind of, although New York actually solved it by getting the federal government to agree that every country that has an unpaid parking bill for millions, the exact amount would be deducted from its aid budget.
Unfortunately, are we still getting aid from America? Kate, please.
I wondered if I could just shift us from your very eloquent speech to an equally eloquent article that you wrote in The Guardian this week. And I'm sure quite a few people here will have also read it, but just to recap, reminding us all again of the Jeremy Thorpe trial, you were explaining why there is a case for jurors to be allowed to speak publicly about what's happened in the jury room, particularly when they can shed light on the way they may have been misdirected or the way in which future trials could improve after juror experiences. And it's a great article, and you almost completely persuaded me. And then I remembered the really unsavory way that in America, after celebrity trials, the next thing you know is that a juror is launching their book and they're on a chat show. And it's not just that they may seek to profit, but that there could be a real risk when it comes to things like jury intimidation, when the identity of which juror in the room spoke against the accused or spoke for the accused is released, and that person then faces retribution. So, given that you've just been making that case in public, could you speak to those points?
Yes, of course. I am not on the same side with other lawyers, judges, but I'm a free speech supporter, and I think, and I'm an admirer of the way Americans, thanks to the First Amendment, are principled. They're adamant about free speech. Of course, jury service is a great event. It's really in a person's life. What goes on in the jury room, if the jury decides it by a toss of the coin, if the jury decides on homophobic arguments or whatever, if something very wrong goes on, of course they think they can speak about it. They can write a book, as you say. Here, you go to prison for 2 years if you breathe a word about what happens.
Quite right,
in
too.
the jury room. Now, Helena represents that British, utterly British view of keep it secret, otherwise people will undermine this. It is the same with the security services. It's the same with the royal family. Our great institutions, we have to sweep any embarrassment under the carpet. We don't want.
It's not totally true, you see, because what happens is that if a jurors, for example, can contact the Lord Chancellor's department and say, we were very disappointed because the judge seemed to be sleeping during a trial, or we actually, felt that certain things were going on that we didn't like, or they complain where they say that in the course of a jury trial, they felt that there was a strong feeling of Islamophobia or whatever. So those sort of things filter through into the system and then are rerouted so that judges are advised to give much firmer warnings about that kind of thing and to draw to a judge's attention if there's anything like that going on in the jury room. And now juries are much more likely to say to a judge, there's been discussions in our room that that's what all Muslims think, and that's not been part of the evidence. Can you please guide us so that people are not being misled by this? And I really have seen the American system up close. And that business of people being able to talk about cases and so forth has absolutely undermined their system. And I think there's far more miscarriages of justice in the American system. It is not a system I would look to for as being the way forward. And I think that we're in danger of imagining that bringing in the cameras, allowing people to talk about everything that goes on is about transparency, and that transparency should trump justice. Transparency sometimes can undermine justice.
I don't think it can in the long run. And
there's no long run if it's an individual's trial. fair trial.
Well, no, individual is entitled to have a fair trial. And if in the jury room there's been misbehavior, bribery, coin tossing, whatever you like, why shouldn't it come out? I'm not suggesting
It's very rare, that sort of stuff.
that fellow jurors should be named, or even
When
the
did
name
you last
of-
do a jury trial?
Oh, a few years ago. I sat as a juror. Let me break the law. Let me get 2 years in prison. A while ago, the law was changed so that judges...
It was the
could-
madness of
that
David Blunkett.
It was David Blunkett, yes, wanted more convictions. So let's put judges on juries.
And policemen.
And policemen, yes. And I was a recorder at the time, and we all got a letter from Harry Wolff, who was the Chief Justice, saying, this is very concerning, because obviously a judge in the jury box will be in the jury room, will have more influence. He said, if you are called, do not let on that you're a judge. So guess who was the first to be called? I was. And we got into the jury room, and some bright spark said, let's go round the table and tell each other what we do. And when it got to me, I said, I'm a grievance counsellor, which was sort of true. And it was extraordinary because, of course, it leaked out. I think I was on a Clive Anderson show that night. And it was, I was elected, of course, as foreman, as your judges.
And you, in all humility, said, no, I can't possibly. Somebody else should do it.
I was foreman, and it was a small theft or something. The defendant was obviously guilty. But we had a couple of anarchists on the jury who said, who took the view that no one is guilty, that society itself is guilty.
Property is theft.
That's right. So here we were arguing unnecessarily, and the clock got to 10 to 1. And I then used my insider knowledge. I said, if we don't agree within the next 2 minutes, we will be locked up for lunch without our alcohol, without cigarettes, and with the court food. They immediately agreed to convict.
This is the human rights lawyer in our midst.
Yes,
Just be wary.
human
Just
rights
be wary.
doesn't mean you don't prosecute
have a human
and
rights lawyer
convict.
on the jury. Get them off.
That's
anyway,
right.
Listen, I think that is the place at which we stop. Otherwise, the whole thing. I do want you to know, I'm halfway through this book, and it really is a fabulous read. And you do write like a dream. I mean, you're an amazing. Very few lawyers can do that, write well about the whole business of law, and nobody does it quite like you, Jeff. So I recommend it to you, and it's out there to be signed. And please join me in thanking Jeff for a very entertaining and interesting talk.
Well, thank you.
Great.
Can I just say one thing? It is Helena's last chairing of this.
Mansfield series talk.
The series will go on, as she says, but we really ought to thank her because we had a most marvellous 5, 6, 7 years of wonderful talks. All she's had to do is to dip into her wonderful, amazing, unrivaled contacts book, and there have been wonderful people, but we have been thrilled by it, and many of us are regulars,
I do
and
have
we've
to
really
confess-
enjoyed it,
I
so
do have
thank
to
you so
confess,
much.
one of the